Hello and welcome to the Estate Planning Toolbox. Thanks for taking some time out of your day to check out everything we have going on here. My name is John Connor and I am an attorney in the Trust and Estates Group of Graves Doherty, Heron and Moody, a law firm located in downtown Austin, Texas. This podcast is a client-focused podcast covering various estate planning topics, including wills and trusts, powers of attorney, corporate entities such as LLCs and limited partnerships, probate administration, and everything in between. Thanks very much for stopping by. Hello, everyone, and welcome. Welcome to the first ever podcast for the Estate Planning Toolbox. My goal for this podcast is to provide you with answers to all of your estate planning questions and to give you the tools and information necessary to have an informed discussion with your personal estate planning attorney. We're going to be covering everything from wills and trusts to probate administrations to corporate entities such as limited liability companies and limited partnerships and everything in between. I'm also going to do my best to keep you up to date on any significant case law updates or legislative updates as those occur. In this first podcast, episode 1, we are going to be jumping into a series that I am calling Estate Planning Necessities, and we're going to start with the document that I'm sure everyone listening has heard of, the will, or as it's sometimes called, the last will and testament. Before we jump into that, though, I do want to start off with a little bit of fun. In each podcast, I'm going to give you a movie quote from some of my favorite movies, and then stick around at the end and see if you were able to guess correctly what movie that was from. This first one is from one of my very favorite movies, and it goes, "Ray, when someone asks you if you're a god, you say yes." So dig back in your mind, see if you know what that's from, and stick around to the very end and see if you were right. So jumping in, let's start with the simple question of what is a will? Very simply, the legal definition is a written document which leaves the estate of the person who signed the will to a named persons or entities, including portions or percentages of the estate, specific gifts, creation of trusts for management, and future distribution of all or a portion of the estate. That is a big, fancy legal way of simply saying it's going to dispose of a person's assets upon their death. It's going to make gifts, it's going to put things in trust, and it's going to appoint a person to be in charge of doing all of that. So what goes into a will? There are 3 simple questions that need to be answered in terms of what goes into a will. The first is, who will be a beneficiary? This could be a person, such as my wife, my husband, my spouse, my son, my daughter. It could be a group or a class of persons, to my nieces and nephews, to my children, or it could even be to a charitable entity. Gifts can be outright, and they can also be in trust. The next question to be answered is, what and how much is each beneficiary getting? Gifts can be cash. They can be real property, such as land or mineral interests. They can be tangible personal property. Maybe you have jewelry or heirlooms or the furniture inside of your home that you want to give away. And or the gift can be intangible personal property, something like a stock or shares in a company. Gifts can be specific. I leave $10,000 to my sister. I leave my residence to my spouse. Anything that's not specifically gifted or listed is going to pass under what is called a residuary estate. It will simply say something like, I give my residuary estate to my spouse if he or she survives me. You'll want to determine, obviously, how much each person is going to get. Are they going to get a set dollar amount? Are they going to get a percentage or a specific item? No right or wrong answers here. It's just something you want to consider when you're discussing preparing a new will with your estate planning attorney. Finally, the question to be asked is, who is in charge? And this is going to be the individual, or in some cases, company or bank, that is in charge of administering your estate. Usually this is called an executor, or maybe the independent executor, or the independent administrator, or the personal representative. This person is in charge of gathering the assets of the decedent and then distributing them to the necessary beneficiaries. They will also be responsible for paying any creditors and dealing with any judicial processes like a probate administration that need to be dealt with. If you are leaving gifts to beneficiaries inside of a trust, you will also need to be sure to name a trustee inside your will or in the trust document. This is the person who is in charge of the trust and has the ability to manage the trust on behalf of the beneficiaries and, of course, make distributions to beneficiaries. Other than those three questions, there are some legal requirements for having a valid will. One of those is that the testator or the person creating the will must have legal capacity and testamentary capacity. Legal capacity means that they are at least 18 years of age or older. It's also a requirement that they have testamentary capacity, which means that the person understands they're executing a will, they understand the effects of executing that will, they understand the nature and extent of the property that makes up their estate. Testamentary capacity also requires that the person know the quote-unquote natural objects of their bounty, which is just another fancy legal way of saying they know who their family members are, their heirs, their relatives, their beneficiaries, and who they're giving stuff to. The person also needs to have the testamentary intent of making the will. This means that they are making a revocable distribution of assets that will be effective, i.e. irrevocable, at the time of their death. In terms of the legal formalities that are required to have a valid written will, those are that the will needs to be written. This does not necessarily mean it has to be handwritten, though that is an option. It has to be signed by the person making the will. It has to be attested to or witnessed by 2 witnesses who are at least 14 years of age. And it's also required that the signature of the testator and the witnesses be notarized. And the will should, but it's not required, that the will be self-proved in the manner that is provided for in the Texas Estates Code. Finally, just one thing to point out is that there is something called a holographic will, and this is a will that is 100% in the handwriting of the testator. There can be no typed portions of it. The will is 100% in the handwriting of the testator. It does not have to be notarized, but it does need to be dated and signed. And as long as you meet those requirements, then you will have made a valid written will. Though I should stress, you should go and visit with your attorney, and you should not rely on a holographic will. Do I really need a will? This is a question that I get fairly often, and the short answer is a loud, resounding yes. The longer answer involves a discussion of dying testate versus dying intestate, which is probably a discussion for another podcast. But in short terms, if you die without a will, you're said to have died intestate. It doesn't mean that the assets in your estate simply go away or become property of the state. It just means that the disposition of your estate is going to be determined by the Texas Estates Code, which means it may not end up where you really intended for it to. This is also a very expensive process, much, much costlier than if you were to die with a will. And dying with a will is what is called dying testate. It is far simpler and much more cost-effective for the estate and for the beneficiaries, meaning your intended beneficiaries are going to end up with more in their pocket. And additionally, it will help to ensure that the estate passes as the decedent, the testator, intended, and not just by what the estate code provides for. So here's a quick summary of everything we went over. The will is a document by which an individual disposes of their estate upon their death. There are legal requirements that need to be met in order to make sure that you have a valid written will. When making your will, make sure that you consider who is going to be a beneficiary, what and how much are those beneficiaries going to get, and who's going to be in charge of your estate. Finally, in answer to the always asked question of do I need a will, the answer is yes. Having a will is far better than the alternative of not having a will. If you don't have a will, call me, call your estate planning attorney, and get a will put in place as soon as possible. I really cannot stress that enough. Now, finally, in answer to today's movie quote question, the answer is Ghostbusters. It's from Ghostbusters, one of my very favorite movies, and here's the clip for you if you'd like to see it.
Ray, when someone asks you if you're a god, you say yes!
Finally, included at the very end here is my contact information. If you have any questions that you'd like me to answer, please feel free to shoot me an email or give me a call. I'd be happy to discuss that with you or even consider putting them on this podcast. Thank you all very much for listening. I hope you've enjoyed it, and stick around next time for episode 2.